Good afternoon and welcome. My name is Banaz Mansouri. I'm a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We are the only freestanding legal aid organization in the country solely dedicated to unemployment. The Unemployment Law Project provides free advice and free legal counsel to people in Washington state who have been denied unemployment benefits or whose award of benefits have been challenged. We're here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to share the latest news on unemployment benefits and to answer your questions. This webinar is set up to provide closed captioning, so you can click on the bottom right-hand side of your screen to enable closed captioning. And if you have questions as we move through the session, please drop them in the Q&A box and we will do our best to answer them. I'd like to introduce our speakers from the Unemployment Law Project, Executive Director John Tierpak and Ann Paxton, Staff Attorney and Policy Director. I'll turn it over to you, Ann, to get us started.
Thank you, Banaz. Welcome, everyone. Good afternoon. Thanks for tuning into our webinar. We have another epic week to talk about. It seems to set new records every week, so I don't know what will happen next week. But today, I wanted to talk about first, hold on, I seem to get this to advance. Sorry. It's funny, the closed captioning won't let me advance the slides. Darn it. Okay. Banaz, do you know how to turn off the closed captioning? For a second.
You can disable closed captioning for yourself if you click the live CC button. So everyone else will still be able to access the closed captioning. You just won't be able to see them on your screen because they'll be disabled.
I don't see a live CC button. Sorry. Where is that?
It's okay. I've temporarily disabled them. I'll just re-enable them once you're done with your presentation. Is that all right?
Okay, good. So first I wanted to talk about the Washington State implementation of the Continued Assistance Act, the federal extension of the CARES Act. That was passed last February. What this does, as most people know, is it extends PUA and includes a $300 a week PUC payment. That's the payment that expired July 31st, so that's been revived. It's available right now. It's available for 11 weeks, ending March 13th. The ESD says it is has started processing the extra 11 weeks of the PEUC payments as well. That was supposed to happen by the end of January. And there are very complicated rules for how this fits into the claimants, into the benefit system, but I can give you a very short summary. If you ran out of the original 13 weeks of PEUC and you haven't applied for extended benefits yet, you should apply. You will receive extended benefits. If you ran out of the original 13 weeks of both PEUC and extended benefits, ESD is updating its system now, and it expects to start processing payments for the additional 11 weeks by the end of January, by yesterday. If you ran out of PEUC and extended benefits before December 26th, ESD can't pay you any benefits for any weeks between when you ran out and when the CARES Act extensions took effect. So that will be an interruption for some people. Very complicated rules, but at least there is coverage for a lot of people. Most people also know that the government's pandemic relief program finished paying a $550 flat amount to PUA recipients in January. Big news in the state legislature is that it passed a bill called SB 5061, which was requested by the governor and voted out of, it was approved by both the Senate and House committees on labor. And as the state passed it, it has, as of the last I checked, it still has yet to be signed, but there won't be any difficulty there. What will this do? The main thing it does for claimants is that it establishes the right for high-risk workers and workers who have a high-risk person in their household to quit their job if they and the exact wording is, you can quit your job during a declared public health emergency, either because you face a high health risk related to that public health emergency, or because you live with high risk individuals. So this is very important for worker safety. It was considered a big achievement to get this through. Another benefit is for unemployed workers is that it raises the minimum benefit from $201 to, it's calculated based on average wages, but right now to be about $270. So that's pretty significant. There are some states that I don't even think that's their maximum. I don't even think their maximum benefit reaches that high. The only problem is if you are an extremely low wage worker, you will be stuck getting a lower payment than $270 because the bill provides that you can't take home a benefit that is higher than your salary. And we commented on this, but they wanted to get that through. So that's a slight problem. It just means that people who are very low wage are going to be an exception from the minimum, even though they've qualified in terms of hours, which is how you get monetary qualification in Washington. So it's going to hurt people with very low wages. ULP is working on 2 state bills, and they have made a lot of progress this session, which just started a few weeks ago. First is SB 5064, which we've been working on in different versions over the last few years. This would protect people caregivers who either have to deliver care themselves or rely on outside caregivers who have a job that is somehow interfering with their ability to provide that care, makes it inaccessible. It protects them in the case of needing to voluntarily quit their job. So the stage that's in right now is it's going into an executive session for discussion on Wednesday at the Senate Labor Committee. House version is under development, and that's significant progress. We'll see where it goes. We're a lot more optimistic than we have been in the past about getting this bill through. The other one is also advancing very rapidly. That's SB 5193. And originally this was set up based on a suggestion of Susie Levine to create an adjudicator pool, that is, keep a reserve force available in the cases of recession, high unemployment, so that the Employment Security Department would have a pool of adjudicators to draw upon. There's been a shortage of adjudicators for various reasons, but since they're very difficult to train, they do require several weeks to train. This would take care of a lot of that problem in advance. That was the only intent of the original bill. However, the Senate Labor Committee leadership wanted to expand the bill. So they asked ULP to submit some recommendations, which we were happy to do. The recommendations had to focus just on claims processing. But right now, we're very hopeful that getting these through. They would sort of change a lot of the phone procedures by requiring sort of caseworker approach so that people would not have to call and get different agents every time they call. That's one example. And it would beef up the protections for, let me get this provision. Sorry. It would set up dedicated toll-free lines for people with disabilities, for people with limited English, and for claimants that lack computer skills or access to computers. Remember, this is not passed yet. This is just what we're hoping to get. It would set limits on phone system busy signals on repeat calls. That's when you have to keep calling and recalling, and wait times so that they would trigger mandatory increase in agents. And it would require translation of claimant letters or notices into the top 10 languages of Washington State if the claimant needs that. In addition, the text of each letter, this is the most important one, the text of each letter or benefit or each letter or notice or alert has to be reviewed for comprehensibility. It has to be understandable. And if it doesn't pass the test, then the notice has to be manually created. And this has been a real obstacle because the Employment Security Department, especially the IT department, have tended to insist that all of these notices, and there are millions that go out every year from ESD, that all of them have to come from the computer, but it's clear that the computer is not doing the job right because so many of the calls, and one day last week they received 70,000 calls. So many of the calls have to do with people saying, I don't understand what this notice says. So we're very hopeful that this will make some progress. And we're going to be asking people when this bill and 5064 on caregivers, when they make some more progress, we'll be asking people to contact your legislators to see if we can to ask for their support. The very big news this week is that President Biden has signed an executive order protecting workers who quit over workplace safety. So this is what was just passed in Washington State on Friday, but the executive order would make it a federal mandate. So how does this work? Workers would have a federally guaranteed right to refuse employment that will jeopardize their health, and if they do so, they will still qualify for unemployment insurance. A lot of states don't protect workers' health to that extent. So although Washington does have, this is actually broader than what Washington passed, because Washington has restrictions on reasons for quitting. So this order, when it is implemented, it have to be implemented by the Department of Labor issuing guidance. But this national standard is very significant improvement in the unemployment benefit systems. Now, there are restrictions on it. It does require that if you need to quit because of workplace safety, you can't just walk out of the job. You have to let your employer know that you question workplace safety and request that it be corrected. You can't just walk in and say, no one's wearing a mask, and then walk out later and file for unemployment. If you approach your boss about enforcing mask wearing to minimize the spread of the virus, and they decline to do so, you may have just cause for refusing unsafe work. And it's worth remembering, they say that a general fear of contracting the virus is not enough of a cause to refuse suitable work. Another order that President Biden signed picks up where there's been sort of a dropping off of enforcement of OSHA workplace safety regulations during the Trump administration. So one of the other executive orders would ask OSHA to review its enforcement efforts and could create an emergency temporary standard that would mandate requirements such as mask wearing, social distancing, hand washing breaks, and communication with workers during outbreaks. And the Department of Labor is expected to issue guidance about a worker's right to refuse unsafe work and remain eligible for unemployment benefits within the next week or two. Meanwhile, the American Rescue Plan, that's the $1.9 trillion package of stimulus and support for workers and general support through stimulus payments, is pending. There's a debate in the Senate over what kinds of cuts the Republicans might request. Right now, Biden is asking for $300 per week to be continued through March to have that increase to $400. He's pushing hard to have this passed, but because of the structure of the Senate, the narrow majority that the Democrats have, they're in a position where they may need to negotiate and lower the price tag of the bill. So that's because there's a 50-50 split in the Senate between the Democrats and Republicans, and the vice president can cast a deciding vote if needed, but that's a very narrow margin. So they have a parliamentary process called reconciliation that they're trying to use to get the bill through with just a plain majority. And two other notes: the job search requirements continue to be suspended. Now, those are indefinitely suspended, so we don't have this monthly guessing game about whether we're going to have another month of job search requirements suspension. And we have news that Susie Levine is now going to be heading the unemployment section of the Department of Labor. At least that's the tentative news. We haven't gotten final confirmation on that. Her last day at ESD was Friday. So that's a very important post for everyone. Finally, people might have seen, I just saw this 10 minutes ago, the Seattle Times story this morning about a data breach. At least 1 million Washingtonians' identity may have been stolen in a hack of software, ironically from the state auditor's office. Where did the state auditor get the information? From the audits of the Employment Security Department. It was exposed in a breach in December of Accellion, a software provider that the auditor's office used to transfer large computer files. No place is safe anymore. So the auditor, who's been having a very moral and principled stand on the data breaches that the Employment Security Department went through, is now in the same position. So I'm sure Susie Levine is having a very good day in looking at this news. And that's the news for today.
I would like to add just a few other points. Just the reason the legislature seems so receptive to reform of unemployment right now is they've been getting thousands of calls for months. The Unemployment Law Project has been recommending people contact their state senator, their state representatives, and the governor's office, because often people would call us for help and there was really nothing we could do without a hearing. The usual function of our office is to give people advice or to represent them in an appeal. But if a person couldn't even get their claim processed or couldn't even reach a person to fix something, maybe they made an error in their claim, we would refer people, we would try to advocate and are advocating for people individually when possible, and also telling people to request hearings. But we also told people repeatedly to contact the legislature. So they had an earful from their voters for months. And even in a recent press article in My Northwest from a Cairo News reporter, there was quote of a legislator from Ritzville who felt his office was being turned into an arm of Employment Security Department, that they were handling so many calls. So while a lot of the calls were on individual claims, in effect it had the cumulative effect of advocating for some kind of reform, even though that wasn't the subject of the calls. So now, as Ann said, we're getting to a point where we will be advocating people contact the legislature to support these bills and to call the governor's office or email the governor's office as well to support as well. So that'll be very important in the coming period. So both parties have had their voters, their constituents with problems. And so I think it's ripe for good bills now would be ripe for passage, and so more public support would be helpful. And also with the departure of Ms. Levine from the Employment Security, Governor Inslee will be appointing another person. We have no word on who that might be, but I've been encouraging people to call or email the governor's office to encourage him to appoint somebody who would prioritize processing claims and customer service, because there have been complications with the law with the new pandemic reforms, which came in March, which were a big plus to include more people, but it also complicated things. And while they did add more staff and they did attempt to get through claims, it was not what it should have been. And we hope the new Employment Security Department head will prioritize claim processing, not only now during the pandemic, but to help set up things so that if there's a future spike in unemployment, the whole system is better ready to adapt to that and to handle a crisis like that.
Thanks, John. I wanted to add also that in a work session last week, the legislators really showed, and this was on the House Labor Committee, just how upset they are about all of the constituent calls they're getting, the concerns that constituents are raising. And you can look in vain for this level of concern is really unusual in the past. Here's what one representative said: this is demanding personal service for people who can't get through on the phone. Typically, people just go into a long queue and never get to talk with a person. Claimants want to talk to someone because they're frantic about getting a letter. How do we fix that? Because some people want to talk to someone, they don't want to write about it. They're confused on the process and they're scared. Here is Representative Ortiz Self, who stressed equity and diversity. She told the chief technology officer of ESD, at the risk of sounding like a broken record, can we get information sent back to us as to how much of these technology solutions are available or modified for people with disabilities or people with limited English? She also said, I want to acknowledge that I'm aware of the unprecedented nature of what ESD has been facing, but I am concerned that a year into the pandemic, we are setting a goal of 18 months into the future for a 10% improvement in equity for our most vulnerable communities. You don't really hear the department being called on the carpet to that extent. And also on overpayments, another representative brought up the issue of the vast number of calls they've been receiving by people who are confused by the overpayment notices they've received. And many of them were given, as you know, 26,000 people got notices giving them 5 days to respond. And when they didn't respond in 5 days, as 13,000 of them did not, they were hit with an overpayment notice. This representative said, how often is the claimant not at fault for the overpayment? Because you can imagine the ones we get calls from are where it's no fault of their own. They were told they were eligible, and then all of a sudden they're told they owe $10,000. So those are the ones we really get concerned about. And getting some accurate data on what that looks like would be helpful to us. This, in the years I've been listening to the legislature, this is a very high level of concern that they're expressing. So it will be interesting to see which direction this takes.
Thank you, Anne and John. And what I love about all of that is that it's not ULP only carrying the water or carrying the message, that the high level elected officials are also mimicking and carrying our message, the same message, directly to the people who can affect change. And they are the people who can affect change. And I feel it's impactful when this messaging comes from different sources. I think that it is important that everyone reach out to their legislators to share their voice and their opinion. I have dropped the District Finder link and the governor's online contact form in our chat box. And Anne, on behalf of everyone here, as our policy director, I want to thank you for your tireless and ongoing efforts in keeping us apprised of these bills and also advocating and testifying on behalf of ULP and all of the thousands of claimants that we represent. It is an enormous task, and know that it is deeply appreciated.
Thanks, Anne.
And regarding the breach on the auditor, it brings to mind the phrase of people in glass houses shouldn't throw stones. I just have to get that in. All right, let's move on.
Story.
That's right. We have two questions. One, we have a participant who has been receiving PUA since March of 2020. This past week, they received an alert saying they needed to reapply for unemployment insurance and that they need to look for work. They have received payments through January. Now, I'm uncertain if they are on PEUC extended benefits at this point. I have sent a message, so if they're listening and they can respond, that would be helpful. But their question is, do they need to reapply last week for PUA or look for work or do a work source class, or what advice can we offer?
So I'm not going to try to explain the PEUC and extended benefits variations. There's so many different ways any claimant might be affected. But if you go to the esd.wa.gov site there and put in PEUC, if that's your program or extended benefits, you should get an explanation about what the implications of the CARES Act extensions are. So it depends on when your benefits were received and when they expire. This sounds like another confusing notice, the kind of thing that we hope can be corrected by what used to be done by hand. And it didn't break the state when it happened then. So I think it's worth getting on the table, and that's what we've tried to do. But the ESD site does have more explanation about exactly what rule applies for which group.
Thanks, Anne. I dropped the link in the box for that. John?
Well, just in terms of looking for work, this is part of the problem. We know, and it's been public knowledge, that the job search rule has been suspended since March. It was originally only going to go for a few months, and then it kept getting extended. The confusion a lot of people have is you have to be able and available for work, suitable work for regular employment, but you may be eligible for pandemic unemployment if you're not able to work due to childcare issues or the virus or caring for viruses, other things. So it's very complicated and messy, but they can't seem to fix these things in the system to make it clear, so people believe that they have to search for work when they don't, but they have to be able and available for work, because some people answer the questions that they're not able and available for work when they are, in theory, if they were offered a suitable job with proper restrictions and safety measures. So it gets very complicated. It's very messy. I always go back to sort of general advice. If you're sent a notice from ESD, respond to it, answer the questions as honestly, as you can, or if it's unclear, try to get the best answer. You can always contact the Unemployment Law Project to get advice. But often I find myself, when I do these advice calls, with the same question when the question itself doesn't make sense. But it's important to, in any event, keep your weekly claim going, because if there is a question about your claim or a dispute over your claim, it's much easier if it gets resolved to get those back benefits than if you didn't claim and then you had to put in for a late claim and have to establish good cause. That's more of a hurdle. So answer the questions, fill out any questionnaires. If you're told you're eligible for something or should apply, it's good to do that, even if it's a mistake or on their part. Early on in the pandemic, one of the most common complaints we'd have is when people would say, they're asking me to file for an extension, but I don't need an extension. Well, yeah, maybe you don't need an extension then, but there's no harm in filling out the application for the extension that may be needed later.
Great. Thank you, John. I also would advise, if ESD is asking you to reapply, then reapply, because failure to do so could lead to a summary denial of all your benefits, and you could be facing an overpayment. If you recall, I believe this happened a few months ago when the federal government was asking individual states to reassess whether claimants who are receiving benefits could potentially receive UI state benefits rather than PUA benefits, and Washington State had sent out notice to PUA claimants to have them reassess whether they were in fact eligible for UI and not PUA. I anticipate this might be something similar. And I do know that in that instance, claimants who did not respond, some of them did face a denial and an overpayment. So as John mentions, respond truthfully, and it's easier to deal with any after effects once you've responded than to fail to respond and have to now face the hurdle of a denial and an overpayment. All right, let's move on. We have a participant who has a client who was receiving unemployment benefits. However, last September, she stopped getting payments and was placed on a fraud alert because her address had changed. ESD told her she'd done everything she needed to do to verify herself to the fraud department, and it should be cleared up within 4 weeks. She has now not received a payment in 20 weeks. 2 weeks ago, her status changed from pending to processing. Aside from calling ESD and contacting her representatives, is there anything else she can be doing?
Well, again, contacting her representative is probably the first best thing. Also, some members of the news media, Michelle Lee at King 5 News, has been advocating for claimants, so that's a possibility. You're welcome. Anyone, of course, is always welcome to contact Unemployment Law Project. We attempt to make contact and get clarity. The results are mixed on there. Sometimes it can lead to some resolution or information, and sometimes not. Sometimes the message we get back is something like, your claim is pending, or the claim is in processing, or we have escalated the claim. I'm not really sure what that actually means in practical sense. And then other times we can get an answer, so that they are welcome to contact the Unemployment Law Project.
The auditor noticed in one of the audits of the department that last year there was a decision made to suspend an ID verification plan because of cost, and of course the result of the fraud has been far exceeded the cost of any program. So ESD has not been quite transparent on what kind of ID verification they have now, and allegedly that's because they want to prevent fraud, but we don't exactly know what they're doing. But it's something they're working on, but we haven't got details.
Great, thank you. Regarding an application showing up, we have a participant that had that happen to them last summer. They never had any explanation as to why an application was demanded of them. They ignored it, and it seems to have been ignored by ESD as well. They assume it may have been a new employee mistake. Since ESD has made other mistakes, do we have any insight?
So this would be a request to file a new application for benefits. That could be for a variety of reasons. So it's not easy to answer that. You definitely, I don't know what to recommend for this. Maybe you have one.
We've had a lot of problem with this use of the phrase new claim. Anne has talked about this past, where it shouldn't be you are eligible, or you may be eligible for a new claim, but it may be you should be eligible for another program or something like that. Might be a more accurate way. So that creates a lot of confusion. Because I've talked to many people over the months, and like, well, why do I need to file a new claim? I already have a claim going. And so it could be telling somebody that they should file for an extension, or it could be maybe they're discovering that the person was on PU, was on regular unemployment, but should be on PUA, or they're on PUA, but they should be on regular unemployment, because there was a lot of that kind of problem where people were put, in spite of providing correct information that should have been pretty obvious as to what program would fit better, still this comes up. So it's been very difficult, because it doesn't have like the linear quality I was hoping. Back when the pandemic started, I was hoping that it would be set up so that people could just apply, and that whatever information was given would then put the person, the adjudicator would then put the person in the proper program. But instead we have this process of having multiple applications with multiple programs, which has led to a lot of problems. The good news is that some people I've talked to have had these issues resolved, and I don't want people to be discouraged. We're talking about all the problems with the system. And of course, nobody calls our office to say things are going great with my unemployment. But of people who've had problems, I've gotten some callbacks and messages back from people who've had these issues resolved successfully. So it's important to not give up, and to keep, if you are unemployed and you are all eligible, to keep claim and fill out whether applications are needed.
Yeah, and I just want to add, there is a range of reasons why you could get a request to file a new application or to switch benefit programs. For example, I mean, you might be in the wrong program, and that could be due to a mistake, but also circumstances change, and the information that ESD has received might change. If you were collecting PUA benefits, for example, because you were a part-time worker in 2019, and just say in August, ESD receives information from an employer that you actually had more than 680 hours, that means you don't qualify for PUA anymore and you have to be switched over to regular benefits. But there are a lot of other ways that this can happen that are not so straightforward. But there are ways that it's just a matter of updated information.
Great, thank you both. There are currently no questions in the Q&A box, so we will wait another minute or so to see if anyone has any questions. Please drop them in the box and we will get to them.
You know, one thing I want to put out there while we wait is a lot of questions I've been getting individually, because I've been speaking individually with many people who call back, and there's a lot of uncertainty as to what's going on now with, you know, waiting week issues or transitions to new programs, what's in the news. And it's just, rather than get more clear, it's got out. And it's unclear at the moment, you know, how the new administration, you know, programs are going to play out, how long they will go, what the political backing will be. Will there be filibusters or compromise on these issues? You know, that's all up in the air. But it kind of comes down for people, you know, I always, you know, that idea again of repeating of keep claiming, because I think when people try to like analyze specifically, well, am I going to really, you know, be qualified for this week? As long as you provide that correct information when you file, you're in good shape. And if it turns out to be an overpayment, you can always request a hearing and ask for a waiver. There are different, you know, things like that. And there's been some good news with waiver for the pandemic unemployment. There had been there's a flaw in the law that didn't really talk about waivers. So we saw these cases where somebody would get an overpayment notice in a hearing over their base amount, but then that supplemental pandemic assistance was showing up as an overpayment on their portal, on their SAW account, but wasn't part of that hearing, you know. And so the good news is that overpayments, you know, should be, you know, again, a waiver isn't automatically granted, but it's an opportunity to show that the overpayment was not your fault and that it would be a hardship to repay. So this whole issue of overpayments has led to a lot of stress and a lot of problems, but I would encourage people to, again, if they get any overpayment notices, request hearings and to follow up with the idea of a waiver for any other overpayments that they might receive. Some people who initially contacted me about waivers of overpayments have actually, when there was some adjustments made, when they were in the wrong program and it was fixed, the overpayment went away for that reason. It's just that the money shifted from one program to another. So that's a possibility for a positive resolution. But it's been challenging for everyone, but I urge people not to give up.
Do we have any questions yet, Behnaz?
No, we don't. I did just want to quickly mention, Anne, that I have dropped information in the chat box for overpayments. The Benefit Payment Control Unit is the department that handles overpayments at ESD. I have a link to their site on the ESD site, as well as a telephone number and an email address for you to contact them. Thanks, Anne.
That's great. If we have just a couple of minutes, I want to mention a New York Times article that appeared January 21st. It really shows that this year is kind of a watershed year for unemployment benefits. And this is a very big article. It's gotten a lot of play, and it basically makes 3 points. One is that the current system gives states incentives to scale back their coverage. And this is something we've noticed has been a big factor in people's frustration about getting benefits. In 2019, only 27% of unemployed workers received any benefits. That's called the recipiency rate. In 40 years ago, it was more like 60, 70% in a lot of states, including Washington. So this has been a major a major change. Another point that the New York Times makes is that the program has not kept up with changes in the workplace and the way people work. For one thing, now 34% of workers are gig workers. The fact that gig workers were included in the PUA benefit program was very important because that was the first time that's happened where self-employed people were able to get benefits. Although in Washington, many gig workers are considered employees and do have benefits. And finally, the New York Times thinks that there is momentum now to change the safety net structure. And I think these two new executive orders by President Biden are very significant because they show that the administration believes that there is a federal role here in workplace safety and other issues as well, workplace safety and enforcement of OSHA standards in the workplace as well.
And I would like to add, the federal mandates are very important because when we at the Unemployment Law Project are not happy with some rule or procedure, we'll, of course, complain to ESD, and ESD will say, well, it's in the legislation. Then when we talk to somebody who's familiar with the legislation, they'll say, well, it's based on federal mandates. So it's always like, you know, it can like go around and around. So on a federal level, higher standards, it's excellent. One of the saddest things about a low recipiency rate is the damage it does to the whole economy. Usually when you think of unemployment insurance, the first thing you think of is helping individuals, helping a family pay the rent, buy food for that month so they can get a new job and move on. But when their spending power is not there, when they don't get payroll and they don't get unemployment, that means they're spending less money. And by spending less money, it hurts the economy overall. And it's unfortunate that in all 50 states, you have money sitting in a trust account, in the unemployment insurance trust account, that should be circulating through the economy. And that's a tragedy here. So if you're a workers advocate, yes, you need to support better unemployment claims processing. But if you're a business advocate, you should be supporting better unemployment claims process because your businesses need that money to do well. And because unemployed people, I can tell you, don't save their unemployment check, they spend it. And that money is needed. That's one of the issues now with this issue of stimulus checks going out or stimulus payments. There's concern that some people who don't need it are not going to spend it, and it's really not helping the economy. And I'm not going to get into that issue because there's a lot of opinions on that, but the idea of unemployment insurance as a fact is spent, and very, very few people are wealthy enough to just put it in a savings account. So it does boost the economy, and that's something that should be recognized across the board, because often debates about unemployment insurance are turned into worker versus business when it's really should be a partnership.
Excellent points, John. Thank you so much. We have a participant who has been receiving unemployment insurance, regular benefits. They have now been contacted by ESD, letting them know they are eligible for PEUC. Is this something to be concerned with?
First, I recommend going to the ESD site and finding out everything you can about PEUC extension. It has been renewed, but there are very complex rules. So the answer all depends on where you fit in terms of your benefits when your benefits expired. So check that out. And then if you still have questions, please let us know, and I will try to find out the answer.
Great, and that link is in the chat box, but I also did just send it to the participant directly. We have a claimant asking if their appeal is found in their favor, will their overpayment be revoked?
So if you win your appeal of the reason for your overpayment, say you established that you had good cause for voluntary quit instead of not good cause, then you should your overpayment should be terminated. That's different from applying for a waiver for your of an overpayment. If you win that, your overpayment will be waived. That's a slightly different status. But we've been hearing a lot from claimants that there's not a very fast rate of follow-up on the part of ESD when people win their hearing. Hear back from them saying, "What's going on? I'm still getting collection notices, or I haven't gotten my benefits that I won in my hearing." You've heard that too, haven't you?
Yes.
And John?
Yes, and so just to run through this, sometimes there's another issue that maybe was not dealt with at the hearing as a possibility. Again, contacting ESD or your Senate representative might turn that if it's lost, or maybe there's a notice that wasn't responded to. Yes, if you win the hearing, it's more likely to, get the overpayment wiped out right away. Sometimes there's a processing delay. Again, you can call your senator representatives, call UOP for help with that. But judges in each hearing will can deal with things differently. I've seen hearings where the judge says, "You're eligible for benefits, or overpayment is gone." Other things as well, you technically weren't eligible for this week or that week, but you're eligible for waiver since you provided correct information. But some judges don't want to hear about financial hardship at the hearing and will remand it back to the department. And that means they should be sending you, and it's via the portal, a waiver form, which asks you about your basic household income and your kind of your general financial situation to show if it would be a hardship. And believe me, it's not too hard to show it's a hardship if your income and expenses are matched, or if your income is less than your expenses in most cases, or even if they match up, if you have very, very little in savings or nothing in savings, benefits are granted. But there are a few judges who will listen to that at the hearing. But if you get a hearing decision where the judge remands the overpayment for consideration of waiver, and you don't hear anything back from ESD within a week or two after the hearing, then that's a good time to send them a message, contact them about it, and again, contact the legislature and UOP for help with that.
Thank you. Can we talk a little bit about requesting a stay on the overpayment request while claimants are waiting for a hearing or pending the waiver request?
Do you want to address the dealings with benefit payment control, Benas?
Sure. So as I posted in the chat box, and I also just posted in the response in the Q&A, once you have received an overpayment, if you have filed your appeal, contact the Benefit Payment Control Unit. We recommend sending an email so you have a written documentation of your correspondence, and calling them, letting them know you have filed an appeal for whatever your denial reason was, which led to your overpayment, and asking them to put a stay or a hold on your overpayment. ESD is aware that appeals are now taking up to 4 months to process, but it is to your advantage to ask for as long a stay as possible. People have been receiving up to 120 days. So I would request the maximum, and then as that calendar that day, and as that day gets closer, if you still don't have your hearing date, call them back and request an extension of your stay, letting them know you still have not had your hearing. That is what we've been advising, and people so far have been having very good luck requesting the stay, provided that your appeal is timely. If your appeal for the underlying issue of what you were denied, which led to the overpayment, is late, BPCU will most likely not grant you a stay on your overpayment, and in which case I urge you to call them or email them and ask for as low a repayment plan as possible, just to bridge your gap so that you are paying and you're not facing any type of arrears or what is it when my brain is not working, a lien when they try to come after your wages or any other type of income. And hopefully that will then, you'll at least get some relief by having a lesser payment until after your hearing. But so make sure all your appeals are filed timely. There's usually a 30-day timeline. And once you filed your appeal, contact the Benefit Payment Control Unit and request the stay.
You know, one question I've had from people who can't afford the monthly payments is, well, if I win my hearing, what happens to the money I paid in? And in the past, I've seen them refund the money fairly promptly. So even if a payment, you know, you partially paid back an overpayment and you win the hearing, you should be able to get that money back. Some people are afraid to make those payments, feeling that if they make the payment, they'll never get it back. But that shouldn't be a reason. It might. I know some people I've talked to, it gives them a peace of mind to make the payment and not feel like they're being harassed as much, or to run the risk of wage garnishment if they're working now.
Right.
Yeah, I want to also mention that Washington State has one of the harshest, unbelievably, has one of the harshest overpayment policies in the country. And for example, it's the only one that charges interest on non-fraud overpayments, 12%, which is the highest interest rate in the country too. And there are only 15 states that charge interest at all. So Washington is a huge outlier on this issue. And we tried to get some legislation this session. We probably have not been able to, by now it hasn't got a chance of making it to the floor. But here's what we're asking for. We're asking for all overpayment notices to be mailed and include a waiver application, because a lot of people are missing them on their e-services, and that's not a good thing. And the notices have to clearly explain the reasons for the overpayment. So many people say, I have no idea what this is about. They have to contain itemized details of all the payments at issue. As John was mentioning, sometimes when you get an overpayment, you don't realize that it includes the PUC payments because they're not itemized. When there's a state of emergency, as there is now, overpayment collections should be suspended, and that's what we're going to keep pushing for. In addition to a ban on charging interest and automatic waiver instead of having to go through a waiver application process, if your condition is found to be financial hardship and in the interests of equity and good conscience, it should be waived.
Imagine the positive impact those few changes would have on thousands of people, on their economic security, on their mental health, on their anxiety and their livelihoods. Fingers crossed that those changes do pass. They would have a resounding effect. Yeah. Okay, we have a participant who they're eligible for PUA and were receiving payment until October of 2020. They have not received any money since last October. They have a pending status. Should they restart their claim? And now it seems as if they don't even get a link to file a weekly claim.
So, they're unable to file a weekly claim.
It looks like they're unable to file a weekly claim, but they are asking if they should restart their claim. So I wonder if they have an option to file a new claim. But what information can we provide? They are stuck in pending status.
Well, it's a real mystery as to why. Like, was there a change of circumstance or information, or even misinformation that the department had about why it would stop? Because on the surface, it seems like there's no reason for it to stop. I would start again by trying to call the 800 number. I've heard that if you call early in the day or late in the day, there's a possibility of getting through. Once again, state senators, state representatives, the governor's office can help, and you can always contact ULP and we can attempt a contact to find out what's going on. I would go through all of your notices. One of the problems with notices coming through on the portal is that people don't always check the portal. And this is especially true when somebody goes back to work and they forgot about their unemployment claim, and then they get an overpayment notice through the portal. They don't read it because there's no reason to go through the portal, right? You're back to work. There's no reason. And then they find out later that they're being garnished. So I guess maybe general advice for everybody is, even if you've closed your unemployment claim and are back to work, to check your portal messages, because they are not, when people check that they want to get their messages through the portal, they don't send any kind of paper copies. and that can be a problem. So I would go through your portal if you can and see if there are any other messages or something that denied you benefits for a specific reason with hearing rights attached.
I'm going to need to duck out for another meeting, but I know several of the questions have to do with what people can do when they're not getting any messages from ESD, they're in pending status, or their benefits are frozen. And I have to recommend strongly, contact your legislature. The legislators are fired up this year. They're not going to turn away constituent requests. They really want to hear, most of them really want to hear what you have to say, and they are responding much more, much better than they have in the past. So that's definitely worth pursuing.
And like each Washington resident has one senator and 2 state representatives. And I've heard that some are more responsive than others. So there's no harm in emailing and calling all 3.
Great. Thank you, Anne, for your excellent information today. One last question, John. When is a substitute teacher no longer eligible for unemployment? Our participant is also going to ask ESD this question, but do we have any insight?
Well, so the substitute teacher status, you know, again, assuming the person, this is what's confusing about it. You may be eligible for unemployment as a substitute teacher as a regular unemployment claim. And as a regular unemployment claimant, the regular rules would apply, which would include those reasonable assurance rules, which basically say that you can't get benefits during normal breaks like spring break and summer break. And I'm assuming this is a substitute teacher either in a public school or not a college professor, because there are some educational institutions that run year round, so there's really not any break now. But for PUA pandemic, again, those rules apply, but because I've talked to substitute teachers who are not working as a substitute due to pandemic related issues which qualifies them for PUA. So, you know, again, not knowing the individual, they would be eligible for as long as can be, and should be, if they're cut off recently, they should still be eligible, because if you had a regular unemployment claim, you should be eligible for extensions. If you have a pandemic unemployment, that should still, because pandemic has been renewed now by Congress. So you should be getting it. So maybe if you're cut off, there's another problem in the mix here, which has made it, you know, muddying the waters. Again, try calling that 800 number to VSD to see if you can find out, check your messages, and if not, call our representatives or Unemployment Law Project for help.
Excellent. Thank you so much, John. That's all the questions we have for this week. Thank you everyone for participating this week and every week. You are why we do the work that we do, and your participation and your voice in Olympia is very important. We encourage you to continue contacting your legislators and letting them know what you're going through and what changes you want to seek. We thank you all for joining us, and we look forward to seeing you next Monday at noon. Take care.